Sir, since now we're live, with your permission, I'd like to start the session.
Please.
Good afternoon, everyone. I, Fariha Ali Khan, on behalf of the Asia Pacific WIS Pre-Mood organizing team, warmly welcome you all to today's session on checklist for memo submission. What makes the first Asia Pacific WIS Pre-Mood unique is that it is one of a kind and inclusive of everyone's participation. The ideology behind this mood is to step out of the ordinary and provide an exposure for holistic development and learning. This is an exciting new competition that aims to give training to young budding lawyers and students to improve their skills in advocacy and arbitration. This pre-mood will be an essential part of training for students and arbitrators planning to attend the WIS Mood and WIS East Mood. The skills learned here will also be a key component for future careers in arbitration. For this session, we have Mr. Gaurav Sir as the interpreter. We welcome you, sir. And also for today's session, our esteemed speaker is Mr. Dr. Rajesh Sharma. Sir is a senior lecturer at RMIT University, Melbourne in Australia, and has been the coach of champion team of WIS Vienna in the year 2013, champion team WIS East 2012, and runner-up team at WIS East 2011. Sir, I'm sure the attendees are waiting to hear from you about this. So I won't take up much time now. We welcome you, sir. The floor is yours.
Thank you very much, Fariha. I also welcome all the participants and audience here to join this afternoon session with me today to talk about the checklist for the memo submission. When we say checklist, we are assuming that you have attended our previous session, which was delivered by the MA, Moot Alumni Association, and our colleagues from there have talked about how to write your memo. So we understand you have done that part, and your first memo is due on 9th of December. So it's a pretty close. So that's why we think that this is the time now to consolidate and check where you are and what are the things you should keep in mind when you are submitting your memoranda. With that, I start to tell you one thing is that the whole mooting process is a learning in itself, and you learn several things. And what is happening here is that by writing the memo for claimant or writing a memoranda, you learn how to do a professional legal writing, which will be used by you, or you can use it later when you become a lawyer or you become a lawyer in arbitration. The written part of the argument is basically the whole moot. On behalf of your client, through the memoranda, you are presenting your argument in a written form, and in a written form in such a way that everybody can understand. And if you write it well, and when I say everybody can understand, in this mooting context, you should understand that it will be understood by the people from common law countries, from the civil law countries, even the people who are not speaking English or English is not their mother tongue, they will also read and understand. So your writing should be of that quality that no matter who is marking your memoranda from anywhere in the world, they should understand the basic things which you want to argue. Therefore, your memoranda is very important part in this mood. Of course, the winning and losing doesn't depend on your memoranda writing, but there's a championship, there's a winning part in the memoranda itself as a part of the process. So what you are doing through the memoranda is that you are presenting your client case in a written form, but you are making a persuasive argument. You are presenting a persuasive argument on behalf of your client, but you are doing it in written form. You are presenting your argument in a systematic and logical way, but you are doing it in written form. And to present the argument, which is based on the facts, which is the moot problem, and the law, which is given to you, and you do your research in that. So if you think about it, this is another part of the arbitration. Later on, you will see, or you may have heard, that many times we do arbitration on document basis. And in document basis, written form of the pleadings are important. There is no oral argument. So you need to think in that context of learning part. Generally, what happens in memoranda is there are several parts, And the very first page is a cover page. And this is very important part. Then comes the table of content. Then we have a table of cases, awards, law, abbreviation, dramatis persona, and all the tables which you have to do it. And then the main part of the written submission starts, which starts from summary of facts, and sometimes people also say chronology of facts. Then we give summary of arguments, and the summary of arguments, what you have given in full form, here you have to give only in a shorter form. And then comes the basic part, the substantive part of the memoranda, which we call it argument part. In that one, you have 4 issues in the mood, and you have to write your argument one by one, issue by issue. So you have to give all the arguments within that. And at the end, you have to make prayer to the tribunal that what do you want the tribunal to do for your client? And then you make an appropriate argument, appropriate relief. Now we see also that like a lawyer, even the students, they sign the page, the signature page, where they say that they have prepared the memoranda and they sign it over there, and like a counsel. So that page is also included in that. So we will take care of all, or we will talk about this all one by one. The very first page, I can say that the cover page on the top, it is written that for which moot you are submitting your memo, whether it's for the Vis East or the Vis Vienna. So you must write that moot first, which you want to submit your memoranda. Then you should have a minimum indication. You should have that on behalf of whose party or which party you are making an argument. And this is a claimant's argument, so a memoranda. So therefore, you are writing on behalf of claimant. So you must write the memoranda on behalf of claimant. You should write that one. And on the bottom page, you write your name of the counsels. So this is a standard. But what you need to check here at the time of submission is the name of the moot. What happens is the one university sends 2 teams, one in Vienna and one in Hong Kong, say for example. And if they are all working together, the general tendency of the team is to prepare one memoranda, and at the last moment, they submit 2. But many times we have seen while marking the memoranda, we have seen that they forget about writing the name of the university or the name of the moot. So sometimes the team which submitted the memorandum in Vienna, they have also sent the same in Hong Kong, and on top is written memoranda for Vienna. Vienna moot is written over there. That is very wrong. And even if it's a mistake which is unknowingly, it happens in rush. But the problem is, even if your content is very good, we cannot rank this memoranda very high so that it will go to the website and people will see. How can we ignore? How can we say that the cover page is wrong, but still you can win the award or win the championship? Not possible. Or winning the honorable mention. It's very difficult. So be careful about that. Check the cover page, though it's not so important in terms of substance, but in terms of formality, it's very important. Second thing, you should take care of the table of content. Table of content, you can make it manual or automatic. But we see that 99% cases, Word file has a very good technique of converting all headings and subheadings into table of content. So basically, everybody writes the table of content using automatic function. But when you use automatic function, it's good, there's no problem about that. But what is more important is that when you read the table of content, your heading and subheading must give a story, must give your line of argument. Generally, when we are marking, just by reading the table of content, we can understand the quality, we can understand the line of argument, because the table of content speaks for itself. And therefore, our suggestion is that when you are selecting the wording in heading and subheading, please be careful about it. Write it the way you want to argue it. So for example, as a claimant, you have a choice. You can just write a heading, jurisdiction. But if you say jurisdiction, is very common. I can't understand what you are arguing. But on behalf of claimant, you are saying that the tribunal has jurisdiction. Then you can say this tribunal has jurisdiction. And if it is written in the table of content, it will be very clear. But of course, substantive part will also be seen, but the table of content is very important. When you are using automatic system, we suggest you to check couple of things. What happens, which generally we have seen. A table of content, when you are in, it should indicate the right page number. Most of the time, 99%, it is there. Whenever you are saying issues and sub-issues and grounds, all which you are listing it, that should be listed properly and you can read it. Sometimes what happens, the auto version, it either takes the paragraph of your substantive argument and puts in the table of content, or the lines are crooked, or the page numbers are not aligned. So you need to see that. It is again about the appearance, about the looking, how good it is there. It's same like memoranda or all these things which we are telling you is like packing your gifts, the gift wrap. Even if the gift is very good, very high quality and very costly, but the packing is not good, then it doesn't look extra good. So you have to cover all those things. So please check in the table of content. The key point that your table of content should give an indication of your line of argument. So subheadings will also tell us how many arguments you have, and everything we can read it. If it is an automatic function, then we can just click from there and go to the main part, and we can read that part and see the level of your writing, and we can see level of your research from there directly. So that's how the examiners or the people who are marking, they also do that in sometimes. Now, once you prepare the table of content, then after that, you have to give table of cases. Ideally, the table of cases should be there, because without table of cases, your memoranda will not be very good in that case. So when you are doing it, please list it in alphabetical order. Alphabetical order can also be selected either by name of the case, or by name of the court, or by name of the country. But of course, by name of the court will not help, because every country has a Supreme Court. So you can't just Supreme Court of Austria, Supreme Court of Australia. That will be very lengthy way. It's not very good way to do it. The best way to do it, either take the cases by alphabetical order with the party's name, or you can divide it into country wise. You can write the name of the country, and all the cases which you have under that country, you can add it over there. So that's you can do that. But what is more important is that no matter what style you choose, but you should be consistent. Whatever way you have arranged it, you should be consistent. You can't be like inconsistent. And this is what happens when the memoranda is ranked for honorable mention on a higher level. Then these minor issues are checked. So if this two memoranda is very close, then one memoranda is very consistent and another is not, then in that case, the consistent memoranda will be given award or move forward, but other memoranda will not move forward. That is what it happens in this case. Now, when you are writing cases, you should also be careful about that. Where you have used this case in your text must be written in a page number. So you have table of cases and you should write on which page number or paragraph number, basically you have used this case. So give an indication. This is a requirement in the mood. When you write the first time, of course, the case will be very long. When the case is very long, court name and year, everything is there, full citation is there, then what you need to do, give a brief abbreviation of that case, the way you are using it. Say, for example, you can just say that cases like you can say machinery case, for example. So full name and machinery case, and that you use in the text. That will save the space in your text, so that in 32 pages, you can write most of the things which you want, and the name of the cases will not take so much of your time. So that's the way we try to do that. Similarly, in arbitration, awards are also very important. And when award is important, then you have to write the award. Same like cases, arrange it in an alphabetical order. Again, here you have a choice. Either you can use country-wise or the name of the institution or name of the parties, whatever the case. But in arbitration, you do not get party's name on the award, so you will not get it. In general, like if you are referring to ICC award, then you will get ICC award number such and such. So this is what you will get. So you need to write that. On some of the website, you can also get shorter version of case, like mushroom case, machinery case, steel case. So you can take that and you can use it. Again, the key point is consistency, arrange it alphabetically. So this is for award. Then you also need law, a statute, rules, and all those things. Again, it's a very simple way, use it alphabetically. For example, arbitration law or the model law. If you are writing it, if you are writing UNCITRAL model law on international commercial arbitration, if you are using full, then it will go on just like, starting with you, and it will come on down. But if you're saying arbitration law of such and such country, then of course it will go up. So it's a very simple technique, just arrange it alphabetically. There's nothing new about it, but key point is consistency. You should have the category, and consistency is good. Then you will have scholarly writings, books, and articles. When you are citing that, again, list them alphabetically. Author's name, either you take his first name or the family name, but whatever you are taking, follow the same and be consistent in that case. Again, when you are writing it, say for example, Gary Bond has written 2 volumes, 3 volumes, articles, and so many things. So when you are referring to him, you cannot say Gary Bond 1, Gary Bond 2, Gary Bond 3. Yes, you can do that. But give some kind of like indication in your table, so that is the same abbreviation. You will use it in your text, and so everybody will know what you are referring to. This is the point. As much as you can be clear and easy to understand, then your writing is good and you will get your due marks in that one. We also say that many times we are using abbreviations. So say, for example, sometimes people say Danubian arbitration law. So instead of writing Danubian arbitration law, they make it short form and they say DAL. Now, in the text, when you will write DAL, we will not know what you are saying. So we have to go back and check your abbreviation and see what you have written. And that's why in the text, we suggest that the first time when you are writing, you can write full. But most of the time, in order to save their space, teams, they do not write. So at least a table of abbreviation, it helps. In my first lecture, when I said that how to read the mood problem, I also suggested to prepare the list of actors. We call it dramatis persona. Who are the people involved in the case? You should also have a list of that. And that list also you can arrange it properly. And when you are arranging that list, you should write a brief description about the person. Say, for example, contract negotiator, Miss So-and-so. Then you can write, she was the contract negotiator from claimant. So you can give some brief about that. So it gives a brief description, very nice on that one. So these are the things initially on the in the mood memoranda writing, you should have these pages in that one. A good memoranda, which we say that it should win the award, whether 1, 2, 3 or honorable mention, we say that at least you should have 10 pages of award, list of award, 10 pages of cases, and 10 pages of authority minimum. So in that case, the memoranda looks very balanced, that you have a good authority. This also shows how much research you have done, how much effort you have done, and how 3 or 4 or 5 people as a team has worked together to prepare a good, well-researched memoranda. So that brings you the extra marks for you. Assuming some team has 10 pages of cases, but only 2 pages of cases and 2 pages of authorities. That is not good. And therefore, a good team should have a good balance. This is considered an average. You can have little more, little less. There's no problem about that. Now, up until now, whatever I was saying, all those pages which you write is not counted towards your memoranda pages, with 32 pages which you have been given. But from now, if you write summary of facts, it will be counted towards your memoranda. And summary of facts should be something which you should write. It should be good enough to tell us that what are the material facts which has given rise to the dispute, and so that we can form an opinion. It should not be more than one page, not be more than one page. But when you write it, don't be judgmental. If you are a claimant, don't say everything nice about yourself and bad about the respondent. You can be neutral as much as possible, just state facts. You can have little bit of a spice in that to say that you have done everything right, but claimant has, or respondent has not done, or whatever you want to it, but just a little bit. But at the same time, you should not be so generous that as a claimant, you start writing good things or good facts or the strong facts of respondent over there. So try to give as neutral as possible, as simple as possible, and all in one page. Sometimes team also like to write chronology. If you are using chronology, then you may avoid summary of facts because your page will be limited. It will eat up your page number. So therefore you choose. But our suggestion is that you should use summary of facts, because it is another skill to write in such a short form that the whosoever is reading it, if they do not know everything about the moot problem or the facts, by reading your summary of the facts, they will know what you have written. That's the idea behind that. After summary of facts, teams also write summary of argument. On issue one, say for example, you are arguing that the tribunal has jurisdiction, then just write one paragraph that why you consider that the tribunal has jurisdiction. Okay. Is the technique, is it going well? I see that our interpreter has frozen. Okay.
I think, sir, there is some internet issue.
Okay. So should we wait for a while? Yes.
So we can back. Go on. Yes, sir.
I think we are back. Can you check with him if he is back?
Mr. Gaurav? Gaurav, sir? Sir, his screen is still frozen for me.
Me too. Sorry about this technical problem. Our sign language interpreter's internet connection has some issue. Once he's back, then we can continue. Do you have his phone number to contact?
Yes, sir, we're contacting him.
I heard in Chennai there's a problem.
Pardon, sir?
I was told that in Chennai, because of rain and other things, like the internet is not good.
Yes, sir. Sir Gaurav sir will be joining once again.
Okay, good.
Yeah.
Very good. And people who are attending this one, and if you have any question, you can write your question in the chat box on the Q&A. And I will take all your questions at the end. Yes, good to have you back. Okay, we were in the same place. I was talking about writing of summary of arguments. Summary of arguments should be issue by issue. So for example, you argue that this tribunal has jurisdiction, then you should give in one paragraph that why you argue this point. And this is a nice summary to write about your argument, which you have developed in 10, 15 pages, which you can write it in one paragraph. Again, the summary of arguments on the 4 issues, if possible, keep it in one page. Just a short summary so that people will understand that what is your main line of argument. You need to also think about that. The summary of argument which you write at the start may change when you finish your writing of memoranda. So now, if you have almost completed your memoranda, then it's time to go back and check and update your summary of arguments. So check again and clear it and make it. Now, definitely your writing and your summary will be much better than the before. You should also remember summary of argument is also counted towards your total page, which is allowed under the rule. So you should not spend too much time here, and you should only write in one page if possible. You should write that. Now coming to the substantive part of the moot. What is happening here is that issues in the moot you have been given 4 issues, and this time you are writing as a claimant, then only think like a claimant and you are writing in that one. So issue by issue, you make your argument. The very first argument which you have, you check that you have followed the same sequence, and you should write it, the tribunal has jurisdiction and why you should do that. But we check that it's always nice when the readers are reading it, when you mark it, all of them are not familiar with the moot, all the facts. So you should be thinking about that. If you are talking, you are going to argue about this issue, then you should give an opening paragraph. An opening paragraph should describe facts which raise this issue. So the material facts which you should say that. And you can also look at summary of the facts which you have written before. You can take it from there and use it here. And then you should start unpacking your argument and say that the reason you are arguing that the tribunal has jurisdiction is because, and then you give 1, 2, 3 point A, B, C, whatever you want to give, and then you run your argument. Of course, this part we have already discussed that how you should do the research and everything before, but I'm sure your substantive part is already done and you should divide. And here it comes, the main issue, 1, 2, 3, which you are writing it, it should be subheadings. Within the subheadings, you may have several subheadings, and then you should start making that tree and writing about it one by one. And you should write your substantive part. The only suggestion we have here is that when you are writing your argument, substantive part, just check for the logic and sequence that you should do that. And this is important for every issue. Why we see you have to have logic and sequence is because sometimes you cannot put cart before horse. For example, if you are establishing that there is a breach of a contract, then the first you may have to argue that there is a contract or not. So that point you need to argue first. So therefore, make sure that you write it in the same way so that the reader can understand. So one simple way or the easy way to write that in arbitration, if you explain the facts, what is these facts? And then you apply, then you use the law, and then you apply the facts on the law to explain your situation. And at the end, you can also use the policy argument to say that how and why this line of argument should be followed. So generally, if you write facts, law, and then policy, then this is your sequence. Once you adopt that sequence, see as much as possible, try to follow that sequence. It is also consistency, and you will have a good roadmap to argue your point. Sometimes for some issue, if you want to swap, you want to change, you can do that. But generally, it is not required. You can do the same way you want to write. You can do that. When you are writing all those things, every paragraph, like, when you are writing the facts, that should be the first paragraph. Then you are writing the law, it should be the second paragraph. And when you are applying it, it should be the third paragraph. That's how you should do that. The idea is that readability should be good. The people should read and understand your story and your line of argument. But don't forget, once you finish that argument, at the end, you need to write your conclusion. Conclusion does not have to have every time heading or subheading. Even the sentences like in conclusion, therefore, and those kind of an indication is good enough to say that this is what your conclusion is on that point. So the key point to check is the sequence, logic, consistency. Those things you should check it if you are doing the checking now when you are submitting it. You should also be careful about the language which is used. You have to remember this is arbitration, not court. In court, we are very formal, but in arbitration, we are not. Generally, in court situation, the lawyers say, I submit. This is a common word, they use it. But in arbitration, we don't do that. We always say, this is our position. This is what we argue. So the word like position, argue, these words are there. So have a look of those words, informal words, which you can use it, not like court language. Those things you should use it. Very important part, that your memoranda will be read by English speakers and non-English speakers from around the world, from different legal tradition. So easy way of writing is a plain English word. Always write short sentences, not too many words in your sentences. Use in a direct mode, no passive voice. Don't use conditional sentences like I would like to argue. No, just argue what you have to argue. Okay. Then when you are writing it, every paragraph should have one theme. Don't mix so many things in one paragraph. If you have so many themes, if you have so many points to argue, break it into paragraphs, and that will be very good. But then don't try to make it paragraph too small, too short, too line, or don't make it too big. If you make it too short, people may say that you are either writing such a powerful sentence that it can be said in 2 lines, which is very doubtful that you can do it or we can do it. But other people will think if this is not that powerful, then why to make a paragraph of only 2 lines? Why not to add it or mix it in the 1 para above or 1 para below? So in that way, you save a space, the pages, so that you can run other arguments in that. So just be careful about these small things. At the end, when you finish your substantive argument, you have to write a page or half a page for the prayer of relief, means what you want the tribunal to do. And that is nothing new. If you look at claimant's notice of arbitration, in the moot problem, claimant has said that the tribunal should do this. You should just follow that. In other words, if you look at that, the key words and the catchwords are there. Sometimes the parties request the tribunal to order something to the party, to declare something to the party, to declare something, order something. So you should write, therefore, you say that in prayer of relief, we request the tribunal to declare that this tribunal has jurisdiction. The arbitration agreement is valid. There is a breach of contract and the respondent should pay the damages and all. So that's how you should write it. But it should be clear that what you are asking. These points are also very much appreciated by the markers when they do that. So far as the other rules are concerned, you should pay attention to the moot rules. Check that how many pages of substantive arguments you are allowed. So keep it under that. In this moot, number of words are not restricted. It is restricted in pages. So follow that page. But by doing the pages, that doesn't mean that you can keep line spacing very small, font size very small. No, it has to be reasonable. And all the rules are there. It should be 0.12, single spacing, border has been decided, how much border you have to left. So all those things, page margin, line spacing, everything is given. So follow those rules. Because again, if whether you should win the champions, win the memoranda award or not, will also be dependent on these things. When the two memoranda are very close, then that's how it is done. And one more time, I can suggest that please, your cover page must have the right moot, Vis East or Vis Vienna, whatever is there, correct name, and your name of the university, and on whose behalf you are writing, claimant or respondent. These things are, if it's not in a proper way, then it will be a silly mistake and it will not look good when the people are marking. Now, some of the points to remember is that when you write your memoranda, it is your written form of argument. It should be logical, clear, and readable. Good English to read it. It should also be dealing with the issue by issue. Say, for example, we have two procedural issues and two substantive issues. So all these issues, you must take it one by one and you handle it. When you are writing it, and if you have decided to follow the sequence, that you will talk about the facts first, then law, then policy, then follow that. If you have decided you will talk about the law first, then facts, and then policy, then do that, no problem. But whatever you do, be consistent. And the consistency is the key to success in this memoranda writing. So this is the point you should do that. Now, I am assuming that you have already written your draft and you are almost ready to submit and you're in a final stage. Our suggestion is that once everything is done, then you set a lockdown period for your moot. Lockdown, I have taken it from the COVID situation, but actually you need to set a timeline. What do we mean by that? It means as a team, you decide that we will stop writing or changing anything 3 to 5 days before the deadline. So if the deadline is 9th of December, then you decide either 5th or 6th of December, you will have a cutoff date. After that, no more changes. A good team have this strategy because even after that, there are so many things you need to do. If you do not do that and work till the last moment, it's not a good sign. It means somehow you are completing your task, but it will not be of good quality. You have to trust us when we say that. I have not seen a team which can write it in one week and they can also win an award. It will be very rare to see that. For that, you have to have very good skills. So don't do that. When we say that lockdown, make sure that as a team, you decide that you will not make any structural changes in the memo now. No more new arguments, no more new changes. Whatever you have done, just you need to perfect that. The only thing you allow is to add addition, some cases, some authorities, and editing. This is what you do. And whatever you do or decide to do, it must be with a view to make your memoranda better than before. When we say some addition, it's very common that once you write, and while you are writing, you may found one case, maybe from UK, and you have cited that case. But after writing memo, during this time, you can find one more case, say from France. Then you can add that French case also. That will enhance your memo. That will enhance your reputation and capacity. That's why you can add that one. But that doesn't mean you can change the argument. You can change the paragraph. If you do that, it will be very, very difficult to do that. So therefore, we suggest that do not change anything 3 or 5 days before the deadline. This is very important discipline in this mood or writing in that. Then comes the editing part. When it comes editing of memo, you will be very surprised that how much work you have to do once you complete your draft. Many times in the team, the students are doing different parts. 4 students writing 4 different parts. And when you combine it together, the language will be very different. It will be not be coherent. It will not be very, very different approach will be there. It doesn't look like you have a memoranda from one team. It looks like you have a memoranda from 4 different teams. And that is not a good sign. So what do we suggest? That you should do the editing of this memoranda. A simple way, if you have a classroom or big room and you have a projector and you have a big screen, then you should project your memoranda in the class or on the screen, and everybody should read it together. If you do it alone, you may leave something, but 8 pairs of eyes are looking at the same thing. They will pick up so many finer things which was a mistake and they can correct it. So in that way, it will be very good. So when you are editing it, at that time, you should also check all your sources again. So generally when you write in a rush, people quote Gary Bourne, Ingeborg Schwenzer, and they write the page number, but it may or may not be correct. And you will be surprised. Many times we have seen that at a very last moment, we found that the quotations were wrong, page numbers were wrong. What the quotation says, it is not exactly the same. We trust our team member, but here we are talking about the whole team. So therefore, it is a good practice, a good discipline that every authority, page number, quotations, while doing the editing, check it. Just check it again. And once you finalize it, then go back to your table of cases, table of authorities. Make sure that you have listed this case over there or the authority over there. Then check the page number or the paragraph number where you are citing this case. So in one time, you can kill 3 birds and you can do 3 things at one time. This is the way you need to discipline yourself and follow a step by step in that case. Assuming you work for the whole day, you may have to work for 2 days on this completing of this kind of editing. Once you finalize it, when you are finishing the job and going home, don't forget to save your file. All the corrections, you save it. Every version, you should keep it. And when you save it, make sure that you give a good file name and the date or the number, whatever you are following. Be careful about that. And 1 or 2 people who are taking the charge of doing the editing, they should be doing editing from now on all the time. And one computer or the 1 or 2 computer, one computer generally they should use it. And whenever you end, whatever the status of your file and the editing is, please save it in your computer and also email to everyone and save it somewhere else. Because we have seen that one computer was used and the computer crashed and the file gone. and that will be very disaster for you at the last moment. So therefore, you should use all method to save your copy. Once you finish the editing, then you should print out that copy, and we call it hard copy reading. When you read on a screen, your eyes acts in a different way. But when you do the reading on paper with the pen or pencil in your hand, it's very different. So what we say is that you print out the copy, which will be around 50-70 pages with all the authorities, and just randomly divide into 4 or 5 parts. If you have 5 members, randomly divide into 5 packs and just distribute the 5 packs among the team member, and ask everyone to read their pack, read that page and see any corrections if there. If I finish, then I pass on to my right. The person sitting in the right, when he finishes or she finishes, they will pass on to other. And in that way, what will happen? Everybody will read the same page 4 times, 5 times. Look at, I will see your correction, you can see my correction, and then we can see whether you have found or not. If you do it, you will be very surprised that after doing the projector or group editing, when you are doing now hard copy editing, still you will find so many mistakes. Again, collect all these mistakes, all these things. Again, your member editors from the team can open the computer, take out that file and start correcting it again. And check once again on the projector that corrections are at the right place and it has been done. If correction is done at one place, for authorities, sources, anything, then you should also check the table immediately over there that everything is in a proper way or not. So that's how you should do the hard copy editing. Now, after doing all those things, I bring the Professor Martin Hunter's gold standard. Professor Martin Hunter, very recently, he passed away. And if you are doing this moot, I'm sure you have come across his name. In 2010, he gave an interview to Indian Lex Arbitrary blog, and he said very nice one thing about it. He said that a good memorandum must have a sound structure, logic, and clarity. Obviously, it should demonstrate ability to analyze complex legal issues, and it should be in a persuasive argument. This is what he says. But then what is more important part he said after that, he said that the final draft text should be edited again and again and again and again. Now, why he said so many times this word, again, again, again? Because even the person like him, he's saying that the writing of the draft, writing of a memo is not an easy task. You will make a mistake. Therefore, you should read it every time correctly and many times. If you think that you have done all these process which I suggested you, then you should use this technique also to do that. If you will be surprised, according to him, he said that every time when you read your memo, you should focus on one specific theme or one specific purpose. According to him, you should have at least 5 readings. And this is what he says. When the first reading you are doing it, it is more about looking at the structure, that whatever the memoranda should have, do you have all those things? Table, cover page, heading, subheading, all those things. So you check on that one structure. Once you finish that, the second time when you read, your focus should be in looking at the validity of the content, your argument, whether it's right or wrong, or whether it's making sense or not. Have you said it right? Have you made any mistake in law? Have you read the facts incorrectly? Check that. This is content part, which you should look at that. Third time, when you read, it should be very technical proof. It's like spelling, grammar, sentences, and according to him, one sentence should not be more than 25 words. Every sentence should contain one theme, one parenthesis, one paragraph in one proposition or one item, which we have discussed about that. So just check that part. In other words, if your paragraph should not be too long, your sentences should not be too long. If it is there, try to break it into 2 sentences, 2 paragraphs. These are the things you should do. And the fourth reading is more about clarity, readability, is to see that whatever you are saying, is it clear to somebody who is not involved in the mood, a lay person? And we say that your writing should be for intellectual morons, that we are intellectual, but still we do not understand. And therefore, you should write it in such an easy way that we can understand. And according to Martin Hunter, Professor Martin Hunter, in his 5th reading, he said that your focus should be need to know test, meaning as a counsel, as a writer, you should have to think about that. Do I have to argue this point? Is it necessary to argue this point? Is it necessary that I should say that, or it is already said? So you need to decide that. It means you have said so many extra things which you should not do that. And therefore you can take it out. So even after the editing, which I have suggested, you do this kind of a 5 readings with the 5 different themes. I'm sure by that time, your memoranda will be of a very, very good quality, a competitive quality, and you should be able to win something if you do that. We say that generally when you are writing your memoranda, and if you want to win any award, it should be drafted 20 to 25 times. Then only you can have achieved that kind of a quality. Now, assuming we have done everything, the last thing that we have to submit this memoranda. We suggest a good team should set a deadline minimum 12 hours before. You should not wait till the last moment. It's a very bad thing. You should do it 12 hours before. We generally say all the team members have worked together, so ask them to come, sit together. You open the computer. If you are editor, you write an email to the mood organizer that you are submitting, or the website where you have to upload, you open it over there. And then when you are uploading the file or attaching the file, please, after attaching, you open it again and see whether this is the file, this is the final copy which you have. Many times we have seen that the teams in the last moment when they submit, by mistake, they attach the wrong file. So many times we have seen the memoranda when we are marking, even track changes are there. Even the comments are there and you can read it. That is not a good sign. So you should not do that. Your file name should be very clear, date, time, whatever indication you have. At least you should have one indication to say that which one is your final draft which you are submitting. When you are attaching the file, you should open it, because generally we submit PDF file. When you convert the Word file into PDF file, sometimes it happens very different. Particularly when you change the computer, and that's why I said don't change the computer, use the same computer. But even then, you will find that the pages have become little different. Page numbers in the Word file, you have a header and you have a paragraph, but when you change into PDF file, there's a hanging headers are there. Margins have become something different. So make sure that you check page by page, that every page is correct. Then you upload that file. When you upload that file or send that file, you can upload it, send it, and all team members are there. Immediately after that, the same copy you should also email to all your team members and yourself too, so that you can keep it. And since you have submitted your draft, it's a time for you to celebrate. You can thank each other, you can clap for each other, you can say that let's go and have a celebration because we have finished the thing. And that's how you should conclude. If you follow this, then you will enjoy it. But if you are struggling to submit it at the last moment at 11:59, then you will not have a time to submit. Generally, we see after submission, somebody will say, oh my God, we attached the wrong file. Oh my God, we didn't add this point. Oh my God, I didn't do the table of content properly. There's something wrong over there. You should not do that. And if you do in such a cool and calm way, then your performance, your submission will be very good and you will be happy with your product. And that's why I say that set the deadline and then set the time for delivery, sending the file in that one. But as a mooter, your job is not finished. The moment you finish submission of your claimant memo, after celebration, from the next day, you have to start working on your respondent memo. Writing of respondent memo is nothing different, is the same like claimant memo. So at this time, you should start writing your respondent memo. After submitting the claimant memo, you should start writing as if you are counsel for respondent and you just have to respond. Then you will receive the memo, claimant memo from the organizers, and then you have to reply to that. At that time, you can check, you can choose some of the code paragraphs, some of the parts, some of the arguments from the claimant memo, and you use it in your memo and say that you are responding, meaning claimant said that the tribunal has jurisdiction. Then as a respondent, you can say that the claimant has argued that tribunal has jurisdiction. In response to that, we argue that the tribunal has no jurisdiction because, and you have already drafted because 1, 2, 3. So all these things you have. So again, you will have those reasons and everything will be one after another. Same, you have what you have done for the claimant memo. Again, you will use your technique, opening paragraph, facts, law, and policy, good research. Again, the editing process when you are submitting the respondent memo, do it again. And if you do the claimant one better and in a nice way, then the respondent one will be very easy for you to do and your quality will suddenly improve. And if you have 80% chances of winning the claimant memo award, then you will have 95% chances. If you follow this technique, then most chances to win the award in that one. So that's how you should do that. I hope this session was useful for you. And if you have any question, I'm happy to take it.
So we have a few in the chat box. The first one is, may we submit our memorandum in this Asia Pacific WIS pre-mood? I know it is not mandatory, but is it permissive?
We are not asking them to submit the memoranda according to our rule. So there's nothing, they don't have to, but if they are submitting the memoranda in the WIS and they want to submit here, that's fine. There's no problem in that one. We are not using it.
All right, sir. And the second question is, please, sir, if you can show us an example or a model of a written memoranda.
Well, I would suggest that the WIS organizers on their website, they have a previous memoranda. And if you do the search, you can find it, the winning memoranda of last year or few years back, and then you can see it. I don't have a memo at this moment to show you as an example, but if you have attended the lecture from Moot Alumni Association, I think they might have shown you that. But the problem is any memoranda which I will give you, it is done by the students from a particular university. So it will not be fair for me to tell you about that or show you that. But on the Moot website, you can find the winning memoranda of the last few years and you can open and check. You will find the same thing over there, which we say. So I'm sorry, I don't have any model at this moment to give it to you, but I'm sure your coaches must have access to many models which they can follow. But let me think about that, how we can do it. And please check our website in a couple of days' time, whether we have any sample for you to follow or suggested sample in that case. So thank you very much.
If there are any further questions, I request the participants to please write them in the chat box.
Or if they have access to, if they want to talk directly, they can switch on their microphone or camera and then they can talk. That's not a problem. And this recording of this video and the PowerPoint will be available which
Sir.
moot you are talking about? When is the moot being conducted and how can we participate? Well, for participation, you just have to register your team with the this pre-moot. There's no problem. You can register and then you can take part. And the oral round is from 10 to 13th of February 2022. You can do that. Yeah, moot court. The WIS pre-moot, the moot which we are organizing, Asia Pacific pre-moot, is scheduled on 10th to 13th of February 2022. But the WIS moot in Hong Kong and the WIS moot in Vienna has a different date and it is given already. So you can also apply there. I don't know whether you can register. You should be able to. But for this moot, registration is open now and you can register here. Check our website of Asia Pacific pre-moot and you will see the registration page and you can just use it. Yeah, Fariha has already put you the link. And thank you very much for showing your interest in joining this moot. Any other question?
Sir, I guess there are no further questions. So with your permission, we would now like to conclude the session.
Sure.
It was an honor for us to have you here, sir. Thank you so much for taking out time from your busy schedule for us. We also thank Mr. Gaurav, sir, for interpreting for this session. And we look forward to our future webinars and are extremely excited for the first Asia Pacific WIS pre-moot. Till then, I hope everybody across this forum keeps safe. Have a good evening, everybody. With that, we shall now be ending the meeting. Thank you, sir.
Thank you. Thank you. Just give an announcement that where they can find the PowerPoint or the video recording on our website. Somebody has asked that. In our moot website, there's a resource page and the event page. You can find it over there. So Fariha will put that information on the chat so you can, everything.